In my hair.
Yes, Your Honor.
All right, Mr. Jury.
Good morning, ladies and gentlemen of the jury. Thank you so much for listening to everything. We know it's been hard. It's been a hard case, and it's been a long case. And no matter what your decision, we want to thank you for taking the time to listen to everything as attentively as you have. When you get up here, this is always the hardest part in the defense attorney's job, is because part of you wants to get up here and outline everything and go through everything A through Z, and part of you realizes that the jury's probably sick and tired of hearing the same thing over and over, and would rather you get to the differences between yourself and the prosecution. And that's what I'm going to attempt to do. We've pretty much heard the story. You've heard Mr. Cataldo indicate very productively that this was a brutal crime and that the person that committed it should be punished. And that's always been our position as well. Big difference, obviously, is that tying any of this to Mr. VanCallis to the point where 12 of you could go back there and unanimously conclude, beyond a reasonable doubt, that he's the person that committed this crime. So what I'm going to do is I'm going to start off by going through the different witnesses and what they said, pretty much in order of what they were here, and what I think are things that you need to consider. One of the most important things that you want to consider as you think about anybody's testimony or anything as you go through life is what I call the 3 C's. Are they consistent with what they're saying? Are they credible? Do they have a vested interest in it? And third, does it make common sense or not? You know? And if you kind of use those 3 things, it's not a lie detector test. It's not going to tell you for sure, but at least it's a little bit of a gauge that you can use in the background to try to assess credibility or the weight that you want to put in somebody's testimony, especially when you don't know. Let's start with the first witness we had. Well, not the first. The first was Ms. Millsap, but there's nothing really to bring up other than offer her our condolences for what happened. Let's talk about the first evidentiary witness, which was FBI agent Zach. He came in here, he indicated to you that he'd worked 15 years with the FBI, and that he had done this animation that he created for the first time with information that he got. He downloaded some phone applications, but other than that, he got information from Finland as to how to use it. He downloaded some things, put it all together, so that animation can only be as good as that. I asked him about the reliability and the validity of that animation, and he said that he had not done any studies to show that. I also, I believe, asked him if he had been out to the scene to see if that reflected that, and I think he said he had not. I'm not knocking the man or his methods, but this is something that's real important, because when you look at that Fitbit application, And I do ask you to look at it. When you look at it, you will see where April Millsap was at about 6:17 p.m. She's on the trail. She's well into the trail because she's going into the park where she goes forward and then comes back. The theory of the prosecution is that Mr. VanCallis goes to the gas station at 6:17 at that Marathon gas station. He goes there, he makes a 1 minute and 41-second call to his brother Donnie, talks on the phone to him, and then after that he leaves, and as we see, he goes left, and then he goes to the right, he goes that way, and then we see him going down south. That's real important, because by that time, their theory is that he's at the gas station and he sees April, and he decides to follow her. That's supposedly what leads to all this. Don't listen to me. Look at the facts and look at that timing. She's already on the trail. There's no possible way that he could see her. Where he's going to church is totally going in the directions that he needs to go. You know, when you get into the heat of battle and you argue about all sorts of things, as we have here, was there dog poop on the sidewalk or not? Was there oil stains or not? If you want to remember one thing real important, you remember we had all these seasoned police officers up here, and every time we talked to them about the direction of the Marathon gas station, they really had a hard time saying, yes, he's going west. And we live in a world and age where things change an awful lot. Which were the two directions which, as we know from testimony, which has been consistent, also lead to Donnie's house and also lead to the Tim Hortons, where he had said he was going. So that's totally consistent as far as that's concerned. He could not have even seen April at that time. She's already well into the middle of the trail, if their Fitbit is to be believed, and you'll see that on there. That's as far as Agent Sens' testimony. He came in, he's very professional, took everything that he could. But whatever animation he creates, whatever conclusions he created from it are his creations. As I asked him repeatedly in the answer, these were creations, not simply download or capture or something that happened. Next we had Trooper Peckman. He's the gentleman that went and saw the motorcycle, if you remember, as he was driving by Moose's house. He had heard of a bolo, be on the lookout for, that may be involved with something like this, a blue and white motorcycle. And he happened to drive by, see the bike. And he took a picture of it. He did not take the license plate. He did not bag the handle grips or anything like that at that time, because I think he was just not sure if it was necessary or not. But at least he thought that that was going to be important in the case. As it turns out, the next day we find out that when he goes and talks to Muse tells him very honestly, it belongs to a friend of mine, James VanCallis, who's over here, comes over here all the time, hangs out. And that's when they went to Mr. VanCallis' house. Now, if you remember, Trooper Peckman indicated when he went there was a female, was what he said himself initially, a young female, and then I asked him, was it Kristen Stadler, and he said yes. She's right with him, and Mr. VanCallis, bless you, showing his shoes, going through, while I'm done looking at the football or whatever, I'm sorry, not the football, the motorcycle and everything else that he's going through. He's asking them if you want to take anything, you take stuff, they take some things, or they take pictures of some things, and they leave. But the important thing is that we're going to come back to Crystal later. Crystal is right there. This is according to Trooper Peckman when all this information has been given, the shoes are being provided, and recitation has been given of Mr. VanCallis' activities that day, of having left about 5, coming back, leaving again at 5:30, and then coming back home between 8:30 and 9. After that, we had what's called the cost video. That's that gentleman, that's that firefighter that we came in and we saw the videos. I would ask you to do the same thing that Mr. Cataldo has asked you to do. Compare that with the Marathon gas station. You're not going to find that that's the same motorcycle. We had Mr. Kloss look at it several times. He looked at the enhanced version that was enhanced by the FBI. He told you he could not tell it as that motorcycle at all. He couldn't recognize it from there, and he told you that very honestly. So no matter what anybody tells you, one of the most important things, I forgot to mention at the beginning of this, one of the most important things is Judge Charnowski is going to give you an instruction which is very important under the law, which means that opening statements and closing arguments are not evidence. It's just whatever we talk. Even if we ask questions, those are not evidence. It's the answers that are evidence. So everything that Mr. Cataldo got up here and told you is his interpretation of what happened. And whatever I tell you, you don't have to take my interpretation. Just go back and follow up and look at the things. That's all I ask, okay? So in that sense, Crystal's right there. We'll get back to her. Same with cost. The video is absolutely speaks for itself. He indicated he had 3 cameras. One was inoperable, and the other 2 cameras, you have the video from there that shows you for a brief time that a bike goes by. Our position is that that is not Mr. VanCallis' bike. Next was Officer Smith. He indicated basically that at least 1,000 tips had come in this case. He indicated he knew that there was some debris pickup at the VanCallis house, and he knew that that dump was searched. He couldn't say with certainty how much of those, if any of those 1,000 tips had to do with Mr. VanCallis. We got to that later with Detective Sergeant MacArthur. But it's certainly none flagged out that he brought with him and said, here, tip number 42 had to do with Mr. VanCallis, and that's how we got those. For 1,000 tips, not one of them be tied in directly to me speaks a lot. Now, when we talked about looking at the debris and anything found, he wasn't sure if they abandoned the search prior to looking through all 16 bags or whatever. I don't think they would in a case like this. They would have kept going. If they're going all the way out, find out where it is, they have the parameters, they go to the dump, they're not going to stop them, especially when they know there's 16 bags. They just thought there was 10 bags, 8 bags, or or a handful of bags. They may not know if they've got to the last one, but here they can for 16. Absolutely nothing of evidentiary value, no shoes, nothing came of that. Next was Mr. Buchanan. That's the miraculous gentleman that has transformed Mr. Cataldo's perception of engineers. Came in, he was very, very methodic about everything that he said. He said 17 miles an hour was his average speed, and he claimed that for that split second that he saw, and 6 feet is as close as he got to 8 feet, that the next split second he could identify Mr. VanCallis. That's why we had him put the helmet on and indicate that you can't see any facial hair. When I asked him about facial hair, remember he said gave that what I thought was an unusual response about eyebrows. Most people don't consider eyebrows and eyelashes as facial hair. I suppose technically it could be, and perhaps in engineer jargon it is. But in everyday people talking, we would talk, or at least I meant, the beard and the face. I mean, you can go back and look at that picture that Mr. Cataldo put up and say, well, you can see the mustache there. You have to really look hard for it. You're looking at it blown up on a high-definition TV in front of you. Out of all the pictures that the prosecution has, that's the one that they felt was most persuasive to have you look at it. Even then, you have to strain to see if you see any hair. You can't even really tell if it's a full mustache, goatee, or whatever. So Mr. Buchanan's identification of the gentleman that he saw with April Millsap is suspect in that. Because first of all, common sense will tell you when you're going at average speed of 17 miles an hour, even if you were at half speed at that time, and you just happen to go by somebody at 6 to 8 feet, somebody you don't know, how much of a glance are you going to get to look at them when they're in the helmet with the shield? Then he kept saying he was 10 out of 10. Nothing was going to shake him, And that's a little bit unusual too, because if you think about it, how much are you folks certain about 10 out of 10? And I'm not saying that he has an ulterior motive, but don't forget, he, like the other witnesses in the case, admitted to you that they saw pictures of VanCallis, and that's when they fine-tuned their identification of what the person was or who it was. Every single one of those witnesses, including Mr. Buchanan, had seen the raid on TV and so forth. Now, let's talk about that. Normally what happens, the whole purpose of a raid or any kind of police action, usually, or military action, is the element of surprise. You don't tell somebody you're going to come raid you tomorrow at 2 o'clock and look for the cookies that you have. You show up there and then you look for what you want to look for. So why was this raid so well announced and everything? It was on all the news. They were showing helicopters, if any of you remember or not, clouds, and then a picture of him is put up all over. That's a little disingenuous. And that's, if anything, I think that led to more problems, because now they're showing these pictures saying person of interest we think might be suspected, and we're going out there because they got more marijuana than they should. It's not exactly Pablo Escobar. And after that, these people start changing their vision of what they think it is. Mr. Buchanan indicated a younger person, teenager, now he comes in here 10 for 10, that's him. I know it. I saw right through the helmet and everything else. So I'm not going to lead to that point, but go back and look at that and remember that he did see Mr. VanCallis prior to identifying him, and he indicated that. Then we had the Spinellas. We had Amy Spinella, which is the daughter. She came in and she indicated that she was going by their bike. She doesn't wear glasses. She wasn't wearing sunglasses. She was riding her bike. You know she was emotional because I think, I don't know if one of the prosecutors, somebody actually even had given her some Kleenex. She very sad about what happened, She's pretty certain that that was April that she saw on that day, at that time, on the trail. She told you it's not Mr. VanCallis. If you think back about her testimony, if you took Any notes, you'll see, she didn't just say didn't look like him or doesn't. She said, no, that's not him. That's my recollection. Go back and look at your notes. But she was much more adamant than, well, I'm not kind of sure. It could be, could not be. She said that's not him, if you remember. And that's one of the best witnesses. That's one of the witnesses that, with all due respect, she probably wasn't riding the bike as fast as Mr. Buchanan or perhaps Miss Stein. But when she's going by, nice and slow with her mom on a leisurely bike ride, she's going to get a very good view. She saw him twice. As you also understand, they were also at the Marathon gas station. So if she thought that that was Mr. VanCallis that she saw on the trail, she would have known that's the guy I just saw at the gas station, or she would have come in and testified. She told you straight out that's not the case, despite her really wanting to help. Next, of course, was her mother, Gail Spinella, and she couldn't identify the person. Said the same thing, younger person. That composite was made, incidentally, from Amy's rendition of her recollection, which is about a younger person, a young teenager, and no facial hair and everything like that. So it was very detailed, as she indicated to. So over an hour, the state police kept asking, do you want to change this? Do you want to change that? Do you want to change anything? And goes very methodically through it. And clearly that person didn't look like that. Next witness we had was Miss Stein. Miss Mary Stein, this lady with Dr. Stein, I suppose I should call her, PhD. She came in here and she testified that while her and her husband were going and riding the bikes by, she saw somebody, a boy and a girl, or a male and a female. And all her original testimony indicates no facial hair, young person. She sees the dog as gray and white, totally different than what Penny is. Penny's predominantly black with a couple of white blotches, as we know, up in the front area. And she calls the police. She gives a description and stuff. Not similar. Later, she sees on TV, composite and stuff. If you remember, I think Mr. Cataldo, one of us could be mistaken in our recollection, but I think he said she called Donahue right away. My recollection was she said she wanted to think about it. She wanted to think about, you know, is the composite right? Is it me? And on one hand, she's realizing that there's a young girl that's dead, and they're looking for the person that inflicted those injuries upon her and brutally did that to her. So how important it is, how important the time is and everything. So that's a little suspect. I mean, that's just, people do things differently. But that's what she did. And then she says that she did finally contact Donahue, and she was told something like, in an investigation where we have the FBI involved, we have the state police involved, we have the Macomb County Sheriffs involved, we have Armada police involved, we have drones involved, we have people contacting software manufacturers in Finland involved. We have practically every kind of science that you could think of, cell phone technologists, everybody involved in this case. Are you going to try to tell me that somebody's going to say, oh, I'm sorry, we only have one piece of paper, we can only do one composite, we're not going to redo it, or we're not going to adjust it? If she had called and been adamant and indicated that that's different. You know, that's something to think about. Now, on top of that, she also indicated that she followed the case online. She followed it on TV. She followed it in pretty much every form of media that at least I enumerated before. She said, yes, 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 I followed it and called the police several times. She was a little bit hesitant to tell us exactly how many times, but many times she called the Crime Stopper line. She had called, I think, Detective Donahue and other people like that. She's just somebody that wants to be a little bit involved. Maybe she feels bad because she doesn't have pertinent information to help. You know, I mean, that's what I would like to think is the natural thing. And then so when she sees this on TV, she says, well, I'll help because that's, you know, any way that I can help. I could have, I should have done more. Just like this Spinelli's indicated. We should have went back, we could have went back, we thought about it, and you know, and did. So it's very natural. It doesn't mean that because people make mistakes in their recollection of what they saw that they're now figuring because of some evil notion on their part. It can come out of very, very idealistic emotions, and that may be the case here. But you have to look at how important this is in this particular case. If you remember when we had you, when we were first picking you folks, we had you answer 17-page, I think, questionnaire, jury questionnaire. There's a lot of questions on there about eyewitnesses and other things, tons of things. But if you remember, we had two potential jurors sitting here. One who was in the academy with Detective Sergeant McCarthy, and another gentleman here who went to cell phone school and everything. I forgot where he was a police officer from. But both of them had indicated, without any argument or anything in this case, knowing who would be or would not be for eyewitnesses, that they felt that eyewitness testimony was suspect, that they did not, you know, trust it as much as some of the other testimony. And that's what they had singled out. Remember, we asked them about that. So that's really important. When you have a trooper that's been with the department many years, and you have the other officer, and that's the first thing that they think of as they're going, because they've seen this themselves. And in this particular case, it's very easy for the prosecution to come up and say, we have a case where we have eyewitnesses that identify this person, but that, you know, they don't mention the goatee, they don't mention the mustache, they say the person's older, the hairstyle looked like a perm in the composite, that the length is different, the height, I mean, and the weight, because they're all saying 5'8", 5'10". Consistently, they're all saying teenager, 5'8", 5'10", and the weight around 180 pounds. As we know, when Mr. VanCallis was arrested, he weighed 205 pounds, and is 6'1". You know, so I mean, it's more than just a little tiny bit of difference there. Now, we get to Mr. Duckstein. He's another person that's an engineer, a very nice guy, came in here, was very honest that I couldn't tell you who the gentleman is, I didn't get a look. But you know, he did get a look at the bike, if you remember, the motorcycle. He went home, and he, on his own volition, went on the computer, and if you remember, I asked him, were you pressed for time? I think I asked him, was this on your own volition, or did somebody ask you to? But regardless, he sat down at his home computer and looked for motorcycles that looked like it, under no pressure to do it quickly or to even do it at all. And then if you remember, he came up with a picture, and that picture is in evidence. I would ask you to look at it when the time comes. That picture does not look like Mr. VanCallis' motorcycle. It has a little resemblance in the colors being blue and white. The tires are different, the fenders are different, the height is different. There's many, many, many differences. And I don't think even Mr. Cotello is going to dispute that. Because I asked Mr. Stein, and all of a sudden he's saying, well, I wasn't really trying to show the colors, I wasn't really trying to show, because he wants to help too. What does he say? I want to show the size. Well, do we really need somebody to spend an hour, especially an engineer, on the phone looking to see, on the computer to show us what size of motorcycles? That was never really a big issue. Again, I think that the man did an enviable thing. He went online, he looked through all kinds of different databases and so forth, tried to find a motorcycle that looked closest to what he recalled, looking like the motorcycle that he'd seen on the trail, and submitted that forthwith to the police. You would be able to look at it. I don't think it was a matter of just size. Now that it totally doesn't look like, or significantly doesn't look like Mr. VanCallis, right? Now we heard some indication that maybe it was just done for size. That doesn't make common sense. It's not credible, and that's not consistent. I think Mr. Stein wanted to help. His wife just testified, but he knows she's very absorbed in the case, and you know, it was just for size he kind of went wrong. He didn't deviate in anything else. Then we had Special Agent Hess, and Special Agent Hess was the person that did the telephone activity, if you remember. And when he does that telephone activity, the same thing. He's supposed to take the calls and plot them. He indicated to you on those maps that show these little circles that they're just indicating direction, not coverage area. He also indicated to you, I believe, that the area was 0.6 miles, that sector 777, the tower that he referred to, if you remember back from your testimony, could go either way as far as the signal goes. We know that from Marathon gas station to where the trail is at, the trail, actually the area where Ms. Millsap was found, is less than a half a mile. So what does that mean? That means that anybody that's in Armada at the Marathon gas station would have been on the same tower, number 777, according to Special Agent Hess. And they're just saying, hey, we don't find anything where they're like in total opposites. We didn't find them together either. Mr. VanCallis has been consistent, has been credible, and it makes common sense in what has been his position to Detective Packman from day one. Remember when he showed up, he said, yes, that's my bike, take a picture of it if you want. Yes, that's my helmet, take a picture of it if you want. Here are my shoes, here are my clothes, here's my body, here's my marks on my leg from cleaning the dog cage. And more important than that, he told him, he said, yes, I was in Armada. He said, I passed through it, I was going out with my brothers, and I went by Muse's house, and I also went by the Tim Hortons, and then eventually to my brothers. Ladies and gentlemen, you have not heard one iota of testimony that conflicts with what Mr. VanCallis had stated from the beginning. If anything, if you remember, we had a fight to get that marathon video together. There was objections, and then all of a sudden it wouldn't play. If you remember, we had to wait a while and get Trooper Packman back in here. Because if anything, I think that marathon video shows a lot more that's consistent with Mr. VanCallis' innocence than it does with guilt. It shows him there at 6:17. When you go back and look at that Fitbit, April is at the trail at 6:17. And Mr. VanCallis is over here making the turn to go here. So she's way over here on the trail. He's actually north of her. So then by the time he's over here, she's going further down the trail. You look at the Fitbit and you'll see what I'm talking about. So he could not have seen it. That could not have been the motivation to say, oh my God, I think I'm going to try to, hook up with this young lady or something. Second thing, the same thing, the no left turn sign. There's a no left turn says you see the bike come back, turn around, go that way, and you see it go in the same direction. You don't hear any lies from anybody. Everybody tells you when they gets to Donnie's house and so forth like that, these people came, they looked to the bathroom, most of these people didn't know. So where would he have cleaned up if he'd have done this? There are people there, not just his brother Donnie. We know that brothers and sisters and family members don't always make the most credible witnesses because they have obviously some love and emotion for the person. But in this particular case, besides his brother, it's his fiancée, Sarah's brother John, his best friend Matt, Samantha, and her friend, Leah, I believe, the one from New York. They're all there. Don't trust them. Hey, nothing unusual. Came in, just wanted to leave for the deer. Didn't use the bathroom, hung out with us the whole time. He wasn't wet, bike wasn't wet, no blood, no clothes, nothing. If anything, he's given a gift. Wrapped toothbrush charger to his brother. Now, ladies and gentlemen, we get to the, I guess, the crux of the case is this whole situation with Crystal. And I think that in his closing argument, Mr. Cataldo somehow tried to imply that maybe I intimidated her or got her to change her answers or nothing. If you remember, I stood up here with some sheets of paper, and every time she gave an answer that was inconsistent with what she had said before, I would refresh her memory and ask her that she'd done that. I didn't say, if you don't say this, I'm going to be all over you or something's going to happen. If you remember, I gave her many opportunities. I said, you want to change your mind? Are you intimidated now? Are you upset? Because that's, what does she do when she's there first, in her first, second, and third statements? And as we know, her statements are being made to state troopers. And I think one time with an FBI agent as well. People that she knows that have guns on them. She's over at her parents' house. And she's going to say she didn't want to tell anything because she was scared. That makes no sense, ladies and gentlemen. That doesn't pass the common sense test. And then the credibility of it. How credible is that? And also, it doesn't seem to be consistent, because she said, oh yeah, all this abuse never came up at the preliminary exam, never came up. This is all new here, this implication that she's some sort of abuser. Even if she were, charge Mr. VanCallis with domestic abuse, if that were the case. She said she never went to the police, no injuries, nothing. So I don't know what kind of abuse, and again, I'm not minimizing it. But her whole story, everything that she says, if you remember about the dogs, she did admit that there was dogs. It took a lot of teeth to get her to admit that those dogs sometimes have accidents on the property. Before she said, oh, no, never. I've never had to clean my shoes. Nobody's ever had to clean their shoes. And then when I pointed out that at the preliminary exam, I asked you and you indicated, yes, there are 5 or 6 dogs, and practically everybody in the house had to come in and clean their shoes off after, because they got feces on them. Confronted with her own words, and she said, yes, that's true. That other thing that she talks about, the hair / hay / straw clump that she was talking about. We had Detective MacArthur, I asked her, she was at the scene, remember at midnight, she got a call about 10, she was there by midnight, she was there the whole time. Or she's been involved in this case the whole time. I asked her, was there any hay at the scene? She said, no, there's no hay there. Again, you don't have to rely on Detective Sergeant MacArthur's recollection or my recitation. Look at the scene pictures. Look at the brutal picture that Mr. Cataldo just showed you not too long ago. Not for the brutality, but look around. There's not a drop of hay or anything like that at all. Look at the pictures of April. There's not a single spot where it looks like even any kind of clump of hair is missing at all. According to Crystal's story of hay and grass and hair being all mixed up in this lump that she found and set on the windowsill and didn't see again. Even in that, ladies and gentlemen, she's not consistent, because when I asked her about it here today, in this case, she deviated again from what she said at the exam, because now she said there was like 2 balls, if you remember. One was hair and one was the grass and the hair. Doesn't make any sense. I mean, how did it go from 1 to 2? That's something very, very, very crucial that you supposedly found in the sleeve. Now, if it's in a pocket, sometimes we all have left things in our pocket and found them inadvertently after the wash. But in a sleeve, in the clothes that have been washed or whatever, it's not sticky or anything. Doesn't make any sense. I don't know where she came up with that whole thing. She came up with things, unfortunately, as time went on. Did you saw you when we were sitting here? We're asking her different questions. She would tell Mr. Cataldo one thing and tell me another. And finally, it was like 10 after 5 that there's just no point in just, you know, having the lady be uncomfortable here. I thought, hopefully we made our points to the jury. So all the stuff that Crystal comes up with, including the fact that, remember, she had said that she would frame him, or she had joked with him about framing him with shoes. And she tried real hard again to deny that, but then when I brought that up from the exam that she had indicated that then, and she said, well, yeah, I could have, would have. Well, why would you, you know, I mean, you're in a murder case. You're an essential witness. Your recollection of everything is very important, your exact recollection. And you say, well, I could have joked with somebody about framing him with their shoes, and yet here we are, allegations of shoes being a big part of the case against Mr. VanCallis. Allegations that didn't come up till the 4th time, if you remember. That long 5-6 hour interrogation. And again, I asked her here, I said, what happened? Oh, no, the police never threatened me. The police were real nice. Did you say that your children and stuff? And yeah. Did you say that you would say that to get out of there? Yes. Did you change your story to accommodate them? Yes. That's her words. That's her words that you folks heard yourself from her exam to here. That's, I mean, talk about inconsistency. Talk about lacking common sense and lacking credibility. That would be a classical example. And again, I'm not knocking the lady. Maybe she's confused. Maybe she's nervous. Maybe she's got a lot of things going at her. You heard how many times she met with these people. She had basically lost track. Said, oh yeah, I met with the prosecutors. I met with Detective MacArthur. I believe even the chief, perhaps. And went over my testimony and stuff. And if you remember, when I was questioning her, how many times did I say, oh, your answer is almost exactly what you had said then, because she basically was verbally from the exam. So the answers that she chose to answer like that, she thought to answer just like that. But then to try to deny that she was threatened, thinking that her children were taken away, denying about the dog feces and how important that is to this case. When you're alleging that a man came in and all of a sudden at night he's cleaning his shoes, and there's an explanation for that, that's an innocent explanation within the confines of the crazy way that, you know, this situation occurred. Come home middle of the night, all these dogs, and wiping that out. So that's important, and she tried to back away from all of that as well. And then the same thing with the hair, and then where she got this, I don't know what she's thinking. But ladies and gentlemen, I think it's exhibit number 74, asked to look at it, that's the autopsy report. You're free to look at anything that you want. There's not a single mention of any hair missing at all from that young lady's body. So if this is a big enough clump that, you know, rolled up, but be in the sleeve, survival wash or whatever, that mixed up with hay and straw under one rendition and then not in another and be separate by itself, I think the medical examiner, if they go into the point where the Civilian Servant Act is there at the autopsy, taking pictures of shoes, we have, I believe, Detective Sergeant MacArthur was present at the autopsy. We have a lot of people paying a lot of attention to every single little detail in this case. And you think they're not going to notice that a clump of hair is missing? I don't know where she came up with that, or what that has, you know, just to add to the story is all I can think of. Now, speaking of the Civilian Servant Act, that's the gentleman that came in about the foot things. If you remember, he said he was given 11 pairs of shoes, and he basically eliminated 10 right away. And then of the ones that were left, he went this way, that way, he tried to come up with the best thing that he could. And now they come in and tell you, oh, the scale is 1 to 8. The man that testified, that's what counts. Not the lawyers that get up here and do opening statements and closing arguments. What counts is the evidence. And what you heard from Mr. Servanac himself was a scale of 1 to 5. How many times did we talk about that? And that's when I try to say, in my mathematically challenged mind, I was thinking 4 equals like 80. You know, like 80%. That's 5 would be 100%. So I wasn't trying to put words in his mouth, but if you think about it proportionately, even then, he said that there was no incidence of association. There was all sorts of things on it that it didn't match, and so it was just one away from being excluded. And remember, those are shoes that they went out and bought in a different size and in different colors to try to get that based on the tread marks that they saw on the young lady. Let's talk about that too, the tread marks. This is also very important. If you go back and look at those pictures, as unpleasant as they are, with the tread marks on the young lady, you'll see pretty much they look pretty consistent. They look pretty new. You know, they don't seem to be tattered. They don't seem to be any nails or any worn or anything like that. The reason that that's real important is Crystal testified that the shoes that she alleges that Mr. VanCallis had, he wore all the time. The black and white ones that Mr. Cataldo has showed you a few times. And I say, oh, those were his favorite shoes. He wore them all the time. Those were his favorite. He wore them all the time. If you remember one thing, if you look at those videos where they show him wearing the shoes, he's not wearing them on the bike one single time. He's always wearing them when he's an SUV or something like that, whatever shoes those are. He has shoes that he wears for, you know, for nice things and shoes that he wears when he rides the bike. I don't know what kind of shoes those are, but if you go back and look at those, not once do they show these black and white shoes out in the field or on a bike or anything like that. So how can, with Crystal saying that these black and white shoes that she's attributing to him, that he wears all the time, would have all these characteristics and stuff, all of a sudden when you look at the tread pattern, it looks brand new. And if anything, she said she'd had these shoes for a long time. So go back and look at some of this stuff. The next thing was Lieutenant April from the Macomb County Sheriff's Department. He's the gentleman that came in and he did the analysis of the video, from the cost video, from the, which was that gentleman at the house and his motorcycle. Took the motorcycle out there, put it back and forth. Me and Mr. Cataldo could spend all day saying, look at the differences, look at the similarities. I will leave that up to you folks when you look at it. But look at that video side to side and stuff. You can, I mean, somebody can see one thing, somebody can see another. And there's no way to identify which bike that is. If anything, I think it's excluded. Now also, you could look at the one that is from Marathon video to that wasn't done in the demonstration that Detective April did with you folks, because it's all evidence. You can look at one piece of evidence versus another piece of evidence and take a look and you'll see that there's not similarities there either, you know. And they tried their best. They wanted to do everything they could. When you have the homeowner themselves sitting there telling you, no, I can't tell that bike. Yeah, see, this is different, and it's taillight bars where the taillights go. So, no, I don't see that there, this. Well, of course you're going to get desperate and you're going to try to do what you can. Now, speaking of desperation, I hope I've never implied that these folks have went out and on purpose tried to frame Mr. VanCallis. I think what it was a rush to judgment. I mean, there's a lot of things that make a lot of sense. If you are looking for blue and white motorcycle, you see one. It's a guy that lives out that way in Armada. And you start looking at him, and then eventually you're talking to his girlfriend and family. She tells you this whole story about him washing his shoes. At night, you hear something about debris being taken out. You know he's got a helmet, you know, on his bike that you have in your possession. You get all excited. You think you've got the guy. The exclusionary, bless you. And especially because he, unfortunately, is one of those flying spirits that's running around checking on his weed, going by his brother or his friend's house. It's not like he went to a movie and he could show you ticket stub. It would be all over them. We could tell you, look, he was watching this movie or he was engaged in this activity and we have him on videotapes. So in that sense, out of that rush to judgment, before the helmet comes back as having any forensic value at all, you heard Detective Sergeant MacArthur indicate there were approximately 80 items sent out for laboratory analysis. We heard from at least 3 or 4 people here, top echelon people, all experts, you know, from Michigan State Police, that they looked at the jury the whole time, they know what to do. Very professional. Didn't find anything of any intrinsic forensic value tying the two together. Same with the cell phone technology and so forth. So then what do we get down to? We get down to these desperation tactics where almost every, or a couple of people are asked, did Mr. VanCallis try to change his appearance? No, he never tried to change his appearance from the day that this incident occurred to the day he's arrested to the day that he looks now. In addition to which, of course, he's lost some weight, but that's, who wouldn't under the circumstances. But also, the same thing about changing the motorcycle. How many times does Crystal ask and other people, oh yeah, he changed his motorcycle, then he changed his fender and all that. You know why? Out of a desperate measure to try to make you folks think that that occurred sometime between July 24th and his arrest on the 30th. And we heard unequivocally that not at all. Whatever changes occurred when he bought that bike on Craigslist, and then he modified it in color and performance to the way that he wanted. Nothing to do with that. So these kind of desperation tactics, I have to tell you, I don't think they have a whole lot of confidence in their own lack of evidence, trying to do the best they can. So, who doesn't want to make Ms. Millsap happy? I wish there was anything in the world I could do. I would, short of giving her one of my daughters, I would do anything in the world I could do for Ms. Millsap, for what was happening. I think that's natural for all of us. I'm sure you folks want to help, and that's a big component of it. Now, speaking along also that desperation, if you remember, I asked Jason April and maybe another officer a couple of times about the shoes. Remember, I said, look, these are clean shoes, these black and white shoes. Oh, no, we can't tell if they're clean or dirty. Or, oh, no, I can't tell from that. The resolution's not good enough. It's not big enough. It's a black and white picture. If you're big, you remember that. And if you remember in your notes. And then all of a sudden, when the prosecution asked him, Mr. VanCallis wouldn't throw those shoes away. Would he? Those look like new shoes? Oh, no, they're brand new. They haven't done, not a speck on them. Same pictures, same resolution, same questions asked by another person. And all of a sudden, now you can tell if they're clean or if they're dirty, if they ought to be thrown away or if they ought to be kept. You know, we have a lot more in common than you would think that we don't, us as the prosecution and the defense. If you notice in one thing in this case, I don't think you've heard me object to hardly anything. And it's not because I'm a wuss and don't know how to do my job or not going to get up there. It's because these folks have been very, very diligent and very professional in providing us all the discovery. Every single picture, every single document, anything else that came in this case was provided to me in enough time to take a look at it, question it if I needed, and that's because of their professionalism, for which I commend them. And they handed everything over, and we were able to look at that and say, okay, that's fine. We had no objections, so I just want to prove something. That's why I think we're at 188 exhibits in this case. You folks are free to ask to look at any of them. Those are all exhibits. And I think there will be jury instruction to this case, but that exhibits that come in, you can look at them for anything. Doesn't mean that because Mr. Cataldo put them in, that you could only look at them for his case or mine. If they showed you something that, works to our benefit, that's free. And if we would have presented an exhibit and it showed something to their benefit, you're also free to do that. Now, another thing about Mary Stein, this will, may come up to you. I got to thinking about this. If you remember, she indicated, and I think Amy Spinella indicated as well, that the motorcycle had a blue and white license plate. If you look at the pictures of the motorcycle, Mr. VanCallis' motorcycles plates are orange. Now, we have people indicating, well, maybe blue and white could be similar, or maybe a dog that's white and gray could be similar to a dog that's black and stuff. I think it's awful hard to mistake blue and white plates with orange plates. That's another very strong thing that came from, I believe, Mary Stein as well as Amy Spinella. Remember now, we're talking according to Detective Sergeant MacArthur, there's approximately 111,000 motorcycles registered. And I don't want to misspeak for her, I don't know if she meant the Tri-County area or the whole area that they looked at, a lot bigger than Armada. There's an awful lot of motorcycles. So think back, next time you're thinking, what are the chances you see a blue or white motorcycle? Is it that unusual a color? Is it that crazy? Mr. Cataldo in his closing indicated a couple of times, oh, Mr. VanCallis' bike is unique. He did this, he did that, he changed this, he changed that. He has two different fender colors. Well, I would think that would stand to reason that if that were the case, people would have had a better time identifying it if it's a unique bike, and you would have had a little bit more precise testimony as to what kind of bike it is instead of black, this, fenders, not fenders, or whatever. In addition to which, let's get back to Mr. Duckstein. He certainly would have been in a position to say, no, fenders were different colors, this was like this was like that, he would have stood up. He focused, I think, maybe because his engineering background or whatever, he was pretty focused on much more on the bike. He couldn't recall most of the other things. So when we talk about commonalities that we have, that's part of the reason why you haven't seen a whole lot of argument. The law is the law. Her Honor will give you the law, and you folks will go back there and decide what the facts are in this case. And unless if the 12 of you that go back to decide unanimously that Mr. VanCallis is guilty, he is to be found not guilty of the charges. And that is what you're charged with doing. We have all taken the oath to defend the same Constitution. The Constitution requires it. If you're thinking in our case, well, you know, this defense attorney is coming up here trying to bamboozle us, I haven't bamboozled you about anything. I've directed you to evidence that's come in and encouraged you to look at it at your leisure and at your time. But I do want to remind you of a couple of things. First of all, we had a kind of mass hysteria in this country at one time around 1692, I believe, in 1693, and that's when we had the Salem witch trials, you know, where somebody would just say, oh, I think this person's a witch. And we would think right now, how can that result in something so bad? But, you know, 20 people got executed, and 14 of them were women, and 5 more died in jail waiting to be determined if they're witches or not, just because of conditions and so forth. So these things happen. It's unfortunate that, you know, I'm not saying that this is per se a witch hunt, but that to make a decision based on hysteria. When I'm done, ladies and gentlemen, Mr. Cataldo will get a chance to get back up here, as he has a right to do and an obligation, and he will continue. I will not get any more chances to get back up here. So whatever he gets up here and says, I can doodle and make all the notes I want, is going to be fruitless, because I'm not going to be able to come back and address them before you folks. So I'm anticipating if he gets up here and shows you some more gruesome pictures, and maybe takes the helmet and beats a few things, maybe stomps some things, maybe throws some boxes around and all that kind of stuff. If you can't, send him some bites. Say, show us some evidence. That's why we're here. This is code of law. And in closing, I just would want to say two things. One is that when you folks do go back and make your decision, whatever it is, if you would talk to us attorneys, we would appreciate that. Sometimes when jurors go back after they make a decision, they don't have to talk to anybody, and sometimes they're willing to talk to one party or not the other. But at least speaking for myself, whatever your decision is, I don't mean any kind of argument and just talking, but I would welcome that if you would. You would just let the judge and the bailiff know. And the second thing is this, ladies and gentlemen, we could sit here and look at the brutality of this crime. We could look at Ms. Millsap, and we could relate, as Mr. Cataldo said, this could be your daughter or anybody's daughter in Armada or anything. But lack of evidence. Lack of evidence tying in this brutality with this person. And that's much easier said than done. Now, there's a time where they said, okay, they came for black people, I didn't care because I wasn't black. They came for gay people, I didn't care because I wasn't gay. They came for Jewish people, I didn't care because I wasn't Jewish. And one day they came for me and there was nobody left to care. Ladies and gentlemen, you have just as much a duty to uphold the Constitution and the laws that our honor is going to give to you. And I think that if you apply those appropriately, with your good conscience, you will find that Mr. VanCallis is not guilty of the charges that are being placed against him. Thank you.
Mr. Cataldo, anything in rebuttal?
Very quickly.
I don't think we've ever argued 1 second in this case that Mr. VanCallis left that gas station and saw her and followed her down to the pen. That's not what the app shows. The story has always been he met her on the app, because when he accelerated down and got to Liberty Path, she was already there. Never was that a part of our case. And also, I'd like to think that the 3 of us didn't pick 12 or 14 sheep, that you would take the words of a retired trooper as what his thoughts of eyewitness testimony was, instead of the instructions and your own common sense and what you saw. Finally, some say that Jesus turned water into wine. I've never seen anybody that indicated they could change oil into feces. The defense is asking you for a miracle. I'm not asking you for a leap of faith. I'm asking you to take a look at the evidence that I presented in this case. I'm asking you to take a look at everything that was done by law enforcement. I'm asking you for justice for April Millsap. What I am asking you to do is convict James VanCallis on every count for the brutal murder of April Millsap. Thank you.
So, ladies and gentlemen, I am going to have my deputy hand to you the jury instructions that I will now read to you. These are for you to take notes on if you'd like. They're yours and yours alone. I'm going to also ask the deputy to give me, I redid the jury verdict form, gentlemen, only to include the case caption. So please review it and make sure it is appropriate, because I do want the original verdict form to indicate case caption. Anyone in the audience? The instructions, it'll take me about 15 minutes to read. It's all about the law. You're free to leave if you'd like at this point. And if you are going to leave, I would appreciate if you would leave now, only because I do not like to be distracted when reading the instructions. And you're obviously more than welcome to stay. Gentlemen, I would hope that you're following through with the instructions with me. And if at any point I make an error in my reading, it'll take a while, and sometimes I do miss a word. Stop me immediately. You have enough copies?
Yes.
All right. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will instruct the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence in my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. When you decide about any fact in this case, it's final. It is my duty to instruct you on the law. You must take the law as I give it to you. If the lawyer says something different about the law, follow what I say. And at various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way, decide the case. The person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is what is judged as a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements, arguments, and commentary are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial of excluded evidence that was offered or stricken testimony that was heard, do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party you're using. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that the witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you believe, any weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant ran away and hid after the alleged crime. This evidence does not prove guilt. The person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. If you believe that a witness previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecution does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The testimony of Michael Sage was read into this trial because he was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you heard in court. You heard testimony about the use of a tracking dog. You must consider tracking dog evidence with great care, and remember that it has little value as proof. Even if you decide that it is reliable, you must not convict the defendant based only on the tracking dog evidence. There must be other evidence that the defendant is guilty. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances of evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to witnesses to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from the following witnesses. FBI Special Agent Matthew Zentz, who has given you his opinion as an expert in the field of digital forensics and computers and cellular telephones. Dr. Mary Petrangelo, who has given you her opinion as an expert in the field of forensic pathology. Monica Burlsky, who has given you her opinion as an expert in the field of forensic biology and DNA analysis. Andrea Abelson-Young, who has given you her opinion as an expert in the field of forensic biology and DNA analysis. Detective Wade Higginson, who has given you his opinion as an expert in the field of computer and cellular telephone forensics. FBI Special Agent Christopher Hess, who has given you his opinion as an expert in the field of historical cellular telephone analysis. Cynthia Edwards, who has given you her opinion as an expert in the field of latent fingerprint examination. And Edward Cervenet, who has given you his opinion as an expert in the field of forensic treadwear analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he or she gave for the opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. Also, think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You may also consider any times that the witness failed to identify the defendant or made an identification or gave a description that did not agree with his or her identification of the defendant during trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, whether it supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant as long as you believe the testimony and you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Millsap died as a result of blunt force trauma and asphyxia due to neck compression. Second, that the defendant intended to kill April Millsap. Third, that this intent to kill was premeditated. That is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of the case. The killing cannot be the result of a sudden impulse without thought or reflection. The defendant is charged with the crime of first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Dawn Millsap died as a result of blunt force trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of April Millsap, the defendant was committing or attempting to commit the crime of larceny and or kidnapping. For the crime of larceny, the prosecutor must prove each of the following elements beyond a reasonable doubt. That the defendant took someone else's property, the property was taken without consent, there was movement of the property, it does not matter whether the defendant actually kept the property. At the time the property was taken, the defendant intended to permanently deprive the owner of the property. For the crime of kidnapping, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant forcibly confined or imprisoned April Millsap against her will. The defendant did not have legal authority to confine April Millsap. While he was confining April Millsap, the defendant forcibly moved or caused April Millsap to be moved from one place to another for the purpose of kidnapping or to murder April Millsap. The defendant intended to kidnap or confine April Millsap, and the defendant acted willfully and maliciously. This means that the defendant knew that it was wrong to confine April Millsap and knew that he did not have the legal authority to do so. In determining whether the act causing death occurred while the defendant was kidnapping or attempting to commit the crime of larceny and or kidnapping, you should consider the length of time between the commission of larceny and or kidnapping and the murder, the distance between the scene of the larceny and or kidnapping and the scene of the murder, whether there is a causal connection between the murder and the larceny and or kidnapping, whether there is continuity of action between the larceny and/or kidnapping and the murder, and whether the murder was committed during an attempt to escape. You have been instructed on the two types of first-degree murder. Those two types are premeditated murder and felony murder. A verdict in a criminal case must be unanimous. To be unanimous, each of you must agree upon which type of first-degree murder has been proved, or that both types of first-degree murder have been proved. If you return a verdict of guilty of first-degree murder, your unanimous verdict must specify whether all of you have found the defendant guilty of premeditated murder, felony murder, or both. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Millsap died as the result of blunt force trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. The defendant is also charged with the crime of kidnapping. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant forcibly confined or imprisoned April Dawn Millsap against April Dawn Millsap's will. Second, that the defendant did not have legal authority to confine April Dawn Millsap. Third, that while he was confining April Dawn Millsap, the defendant forcibly moved or caused April Dawn Millsap to be moved from one place to another for the purpose of kidnapping or to murder April Dawn Millsap. Fourth, that the defendant intended to kidnap or confine April Dawn Millsap. Fifth, that the defendant acted willfully and maliciously. This means that the defendant knew that it was wrong to confine April Dawn Millsap and knew that he did not have the legal authority to do so. The defendant is also charged with the crime of assault with intent to commit sexual penetration. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery on April Dawn Millsap or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person of another. Second, that the defendant intended either to injure April Millsap or intended to make her reasonably fear an immediate battery. Third, that that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. Fourth, that when the defendant assaulted April Millsap, he intended to commit a sexual act involving criminal sexual penetration. This means that the defendant must have intended some actual entry into April Millsap's vaginal opening, anal opening, and/or mouth with his penis, finger, and/or tongue. It is not required that the defendant actually began to commit the sexual act. To prove this charge, the prosecutor must prove that the defendant made an attempt or a threat while intending to commit the act. An actual touching or penetration is not required. To prove this charge, the prosecutor must prove that the defendant committed the assault and intended to commit criminal sexual penetration. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about July 24, 2014 in Holmes County. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room, you will be provided with written copies of the final jury instructions. Obviously, you have them. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing. The envelope doesn't have to be sealed. Submit them in writing and knock on the door, and the court officer will come and take the note from you. If you want to communicate with me while you are in the jury room, please have your foreperson write a note, knock on the door, and the court officer will come and get it from you. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may use your notes in the full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given... Now, the defendant is charged with 4 counts. That is, with the crimes of first-degree premeditated murder, first-degree felony murder, kidnapping, and assault with intent to commit sexual penetration. These are separate crimes, and the prosecutor is charging that the defendant committed each of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any combination of these crimes or not guilty. You have attached a verdict form. Basically, that is the verdict form, but I do have an original for you with the case caption. The original verdict form reads, "The people of the state of Michigan versus James Donald VanCallis." You may return only one verdict on this charge, count 1, first-degree premeditated murder. You have 3 options: not guilty, guilty of first-degree premeditated murder, guilty of lesser offense of second-degree murder. As to count 2, you may return only one verdict on this charge, first-degree felony murder. You have an option of not guilty, guilty of first-degree felony murder, guilty of lesser offense of second-degree murder. You may return only one verdict on the charge of kidnapping. You have an option of not guilty, an option of guilty. You may turn only one verdict on this charge, and that is the assault with intent. The charge of assault with intent to commit sexual penetration. You have an option of not guilty and an option of guilty. It is necessary on my original form that the foreperson please sign and date that form. When you reach your verdict, I am telling the foreperson, whomever that may be, that you should be folding that verdict form in half when you enter this courtroom. At the beginning of the trial, I indicated to you that we would remove 2 of you.
Your Honor, may we approach maybe an error 1 second?
Should we stop the meeting?
Well, I don't have a copy to place it as on the way.
given to me, you were originally given your instructions, and you still have your package, correct?
Yes.
And inside your package, you have a definition. If you have a pen, write it down if you left the original package in the jury room. You were read a definition on 16.4, this number's on top of the instructions, and you were read a definition on 19.1. So 16.4 is the definition of first-degree felony murder. 19.1 is the definition of kidnapping. I want you to take the packet that I gave you, and I want each of you to remove the definition that I read in 19.2. Everybody remove that 19.2 that I just gave to you. And the deputy's going to come and collect it.
Page 9 on the bottom. That's not page 9.
Am I also having them remove 16.4?
Page 9.
Kidnapping felony murder? And also remove the 16.4 that I read to you. So two up here removing, 19.2 and 16.4.
6 on the bottom.
6 on the bottom.
19.2,
Towards the middle.
Page 9 on the bottom and 6 on the bottom.
They're in the middle, kind of.
They're in the middle. 16.4B?
Yes.
0.4B? Is that correct? There's a 16.4 and a 16.4B.
No, you keep your 16.4B. I
Oh.
want 16.4
All right.
Sorry.
and 19.2, that's it.
Page 5 and 9.
Page 5.
Not B, just regular.
Not B. Page 5 and page 5.
16.4, 19.2. 16.4 is felony, first-degree felony murder. 19.2 is kidnapping.
5 and 9.
All right, we got everybody? Okay, so now we've got everybody. I am going to read to you those two instructions that are in your original packet. So you go back to the jury room, you have this instruction, but by law I have to reread it to you. You are to disregard whatever you remember from my reading of the ones that we just took away. So you do have 16.4 and you do have 19.1 in your original packet. So jury instruction 16.4, first-degree felony murder. The defendant is charged with first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of April Dawn Millsap. That is, that April Dawn Millsap died as a result of blunt head trauma and asphyxia due to neck compression. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to April Dawn Millsap, or he knowingly created a very high risk of death or great bodily harm, knowing that death or harm would be the likely result of his actions. Third, that when he did the act that caused the death of April Dawn Millsap, the defendant was committing or attempting to commit the crime of larceny and or kidnapping. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. For the crime of kidnapping, the prosecutor must prove, first, that the defendant knowingly restrained another person. Restrain means to restrict a person's movement or to confine the person so as to interfere with the person's liberty without the person's consent or without legal authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, by doing so, the defendant must have intended to engage in criminal sexual penetration or criminal sexual contact with April Dawn Millsap, a 14-year-old child. Fourth, that the killing was not justified, excused, or done under circumstances that reduced it to a lesser crime. Jury instruction, criminal jury instruction 19.1, kidnapping reads, the defendant is charged with the crime of kidnapping. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly restrained another person. Restrain means to restrict a person's movement or to confine the person so as to interfere with that person's liberty without that person's consent or without legal authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, by doing so, the defendant must have intended to engage in criminal sexual penetration or criminal sexual contact with April Dawn Millsap, a 14-year-old child. So let's get back to, we have 14 jurors. Initially, I told you we would reduce you to 12. We do this by a blind draw process. The clerk has her box, and inside of her little box are seat numbers. So we have seat numbers 1 through 14. She's now removed 2. 2 of you will be removed from the beginning of deliberations. Your seat number is called. Please remain seated.
First juror will be juror in seat 10, juror number 375. And juror in seat 4, juror number 480.
So, folks, you are still considered jurors in this case. You will remain jurors in this case until you get a phone call from us that we either need you back or that the case has concluded. Please give the deputy, when you leave in about 2 seconds, maybe 5, your phone number where we can always reach you throughout this process, and that's inclusive of today as well as Monday and whatever time it's going to take. As you are still considered jurors, you are still excused from work in case we need to call you. I'm not going to tell you not to go, but you do have your excuse because you are still considered jurors. I want to thank you. I know this has been a long process. We may not see each other again, and I would ask that you also refrain from not watching any news accounts, listening to anything, or reading anything. You are now excused. So you two can leave, and the deputy will get your phone numbers. Lunchtime, you might be hungry. If you want to go to lunch, you're free to go to lunch before you begin your deliberations. Please don't take any longer than an hour. When you come back, if you don't choose your support person before you leave, that's your first job, your first responsibility. Get your support person. You're free to take breaks whenever you'd like. Please don't take longer than 15 or 20 minutes. I would like to continue with the process of taking breaks with you being escorted if you need to smoke down to the cafeteria. You can't smoke there, but outside if you need to have your cigarettes. And I would, and I'm going to instruct the jury, have you escorted down to our cafeteria today for lunch. And you can have your lunch there in the cafeteria. You're free to stay today as long as you'd like. And I would encourage you, if you want to stay longer than 5, that's fine with me. I'll stay as long as you'd like. If you continue deliberating until Monday, you'll return Monday at 9 a.m. to resume your deliberations. If you have questions, you need to reduce them to writing in a note, knock on the door, give it to the deputy. Be patient. Sometimes we're not going to hear the knock. You've got to knock pretty loud, and we'll get to you. If you want to see the evidence, again, you need to ask for it, and we will have all the evidence together. If it becomes necessary for you to view anything on the screen that you want to see enlarged, because I do believe you're going to be given pictures of everything, but if you'd like to see it on the large screen, we will be able to bring you out and allow you to do that again. If if you need to see any type of video, again, we will bring you out in the courtroom and we will all view it together. Okay? I'm just going to wait now for him to return. So please, when you get in that room, you get your foreperson and then decide how long you want to go to lunch and then go downstairs. Do any of you have any concerns about like moving your car or anything that you might want to do at lunch? Because you have it downstairs.
I have to get something out of my vehicle, but I'm parked right in front, so I don't know if somebody can...
Okay, well, I'll allow you to go get it. I would like for them to have their lunch down in our cafeteria to avoid anybody in the lobby. So they will be escorted down to the cafeteria to get their lunch if they choose to eat. If not, they can stay here. The gentleman in seat number 3 needs to run out to his car and get something from his car.
Correct.
Lunch?
Nothing.
You can begin your deliberations, folks. Thank you.
Thank you.
All right.